Good morning, everyone. Thank you for being here. Sorry for the late start. Appreciate your presence. I'm California Attorney General Rob Bonta, and before we get to today's announcement, I want to acknowledge the individuals standing beside me. And if it weren't for them, we wouldn't be here to announce what I believe is one of the most significant and far-reaching settlements in recent memory to protect California consumers and promote a fair and competitive economy. So allow me the privilege to thank these hardworking public servants who I know don't do it for the recognition. They do it because it's the right thing to do to help people they may never know and may never know them, but to make sure that they are able to participate in a competitive economy free of any manipulation or undue influence. And so let me thank our legal secretaries, Pauline Santamaria and Claudine Santos, as well as legal analyst Laura Namba, Deputy Attorneys General Brian Wang, Carrie Jeffries, and Lauren Pomeroy, as well as Supervising Deputy Attorney General Michael Jorgensen, Senior Assistant Attorney General Paula Blizzard, and Special Assistant Attorney General Evan Akron. That's the team that helped bring you today's settlement. So every day, these individuals and our entire antitrust law section work tirelessly to ensure a fair and competitive marketplace, and today is no exception, with Californians spending more than ever before on just about everything, from groceries to gas, from health care to housing, clothing to computers. We need to do all we can to ensure the market is fair and competitive so consumers aren't forced to fork over even more of their hard-earned money thanks to artificially inflated prices. So consumers have a choice about where they spend their money, and so businesses that play by the rules can succeed, can compete, can have an opportunity. Fortunately, that's something we can all agree on, and it's why we're here today. So let me talk about our settlement with Google today. The attorneys general from all 50 states, the District of Columbia, and the territories of Puerto Rico and the Virgin Islands have worked together to reach an extraordinary $700 million settlement with Google to rectify anti-competitive behavior that has unlawfully maintained the company's monopoly of the Android App Store. And let me just pause there for a moment, because almost never do you have every state and the territories working together. Multi-state, bipartisan. Let me emphasize that again, bipartisan. And unfortunately, that's more rare than common these days. But when it came to holding Google accountable and changing its behavior and making sure there was appropriate payments to consumers who were hurt, there was vast agreement across states and across parties. So because anti-competitive behavior violates federal and state antitrust laws, and that includes preventing other app stores from being preloaded on Android devices. That means buying off companies who may have launched rival app stores to Google Play Store, and creating technological barriers to deter consumers from directly downloading apps to their devices. They made it extremely difficult for consumers to have options, for consumers to have options that would reduce price, and they essentially effectively maintained a monopoly and gouged consumers and developers in the process. At the expense of consumers, Google has been limiting user options. They've inflated prices for in-app purchases by requiring consumers to pay third-party developers, not directly, but through Google, which takes a large commission, 30% generally. Google created an unfair marketplace designed to funnel profits back to the company at the expense of consumers. The settlement we're announcing today is a step forward in returning fairness and competition to the market, and returning ill-gotten gains back to users. Google has agreed to return $630 million after fees and costs to about 102 million users nationwide. So you can see the breadth and the scope of the impact on consumers across the country. Those consumers made purchases through Google Play, the Google Play Store, during about a 7-year period between August 2016 and September 2023. They paid an unfair price due to the lack of options, due to the commission Google was charging. And we're making this restitution simple, which is different than a lot of multi-state actions where there's an opt-in and a requirement, a burden on behalf of consumers to know that they're eligible and to seek their restitution. So those who are eligible in this settlement don't have to submit a claim. Instead, they'll receive automatic payments back to their accounts through PayPal or Venmo, or they can choose to receive a check if they wish, or an ACH transfer. There will be more details forthcoming, but important to note that we've been able to, through technology and the data that we have available to us about the consumers, get that money back in consumers' pockets without them really needing to do anything. The terms of this settlement will also require Google to take certain actions to bring fairness and competition back to the marketplace. So injunctive relief, changes in behavior going forward. And here's what some of those are. For at least 4 years, Google must maintain Android system support for third-party app stores, including allowing automatic updates, so supporting competition on the phones. And they cannot require most developers to launch new apps or games on the Google Play Store at the same time as they launch on other app stores. So there will be true competition from other third-party app stores. User choice billing is an important part of the settlement and the injunctive relief. It's already being implemented by Google in other countries, but it's only offered in the U.S. currently as a pilot program. So we're seeking to remedy that. And for at least 5 years, Google is required to give all developers the ability to allow users to pay through in-app billing systems other than Google Play billing. So they can pay the apps directly without going through Google's billing system and where they pay that extra commission. We will allow developers to offer cheaper prices for their apps and in-app products for consumers who use alternative non-Google billing systems, permit developers to steer consumers toward alternatives, non-Google billing systems by advertising cheaper prices within their apps so that consumers know their options and they have cheaper, less expensive options. Revise and reduce warnings that appear on an Android device if a user attempts to download a third-party app from outside the Google Play Store. Right now, there are a lot of scary warnings that discourage consumers from downloading third-party apps from outside the Google Play Store. Google is also required to submit compliance reports to prove that they are doing what they are required to do to an independent monitor who will ensure that Google is not continuing its anti-competitive conduct. And the company can't enter contracts that require the Play Store to be the exclusive preloaded app store on a device or home screen. Other app stores can be preloaded onto devices as well. And then finally, for at least 7 years, Google must allow the installation of third-party apps on Android phones from outside the Google Play Store. So that's a lot of detail, a lot of terms and conditions. They all add up to, and the bottom line is essentially that this settlement alleviates constraints that Google placed on app developers and third-party app stores for years, hurting consumers in the process, jacking up prices. California is poised to become the 4th largest economy in the world, proudly so. A status that depends on creativity, on innovation, on entrepreneurship, and also fair competition in the tech industry and all industries. The settlement is about bringing fairness and competition back to the marketplace where it didn't previously exist, and it's about giving consumers, you and me and everyday folks throughout California and this country, more options. So today's agreement isn't the first time California DOJ has held Google to account. Unfortunately, we've had to do so in the past, and we have some ongoing cases now. Just in September, we reached the $93 million settlement over allegations that the company deceived users by collecting, storing, and using their location data for consumer profiling and advertising purposes without informed consent. And in 2022, we agreed to a $9 million settlement over allegations that the company misled consumers by asking DJs, predominantly at iHeartMedia, to falsely advertise personal experiences about the Google Pixel 4 cell phone, a product they hadn't even used. And currently, California DOJ has 2 other active lawsuits against Google, one concerning its general internet search services and search advertising. Testimony concluded in November after a 10-week bench trial, and closing arguments will be held next year, 2024, May, and we're expecting a verdict in the summer of 2024 or soon after, so stay tuned on that. And we have another case concerning Google's advertising technology. It's ad tech. This case is proceeding quickly as the court is known as the Rocket Docket, Eastern District of Virginia, and we look forward to a trial in 2024. So some past cases against Google, the current one today, others that are continuing to move forward. Today's settlement, as well as our active lawsuits, send a clear message not just to Google, but to all corporations doing business in California. If you use your power to illegally bend the market at the expense of consumers, small business owners, and the economy, we'll hold you accountable. We'll see you in court. As the people's attorney, I'll use every tool at my disposal to advance economic justice, protect Californians from greedy corporations that trample over hardworking families for the sake of turning a profit. We will continue to push for fair competition, for fair prices for consumers. And so, to the people of California, you have my word that we'll continue this work. And thank you for the opportunity to share this important settlement today. Happy to take any questions we might have. It's going to vary. We think the minimum is around $2 and could go up from there, depending on the use of the Google Play Store and the level of participation. So big numbers overall spread out among many consumers who are hurt, and each will get their fair share of the settlement. Hi.
Hi. In the recent trial between Attorney and Google, there was a lot of testimony about Google's deletion of internal chats and hiding evidence, and the judge was very concerned about that, and I was wondering if that was a problem in your investigation, and if you're concerned about that practice in general by tech companies.
Yes, and yes. We're very concerned when the laws aren't followed, when evidence is not preserved, where there are deliberate and intentional approaches to not maintain evidence that would be discoverable, usable, potential evidence for a case. It's wrong to do that. The judge was rightfully concerned, had very serious expressions of concern of the level of violation that he saw through this workaround chat at Google, and we're concerned too. When we conduct investigations, we expect compliance, cooperation, and abiding by the law. The law is not a suggestion, something to be worked around or designed around when inconvenient. It's there to be followed. And so when it's not, we are very concerned. And so we have that concern here as well. Yes?
Can you talk about how you balance the economic importance of big tech as a major engine of the state's economy versus these sort of antitrust complaints? How do you balance those two things?
To me, it's not very complicated at all. We support our great California businesses. We are proud of our legacy and history of innovation, of doing things first, of our world and nation-leading industries in Silicon Valley and Hollywood and the Central Valley with agriculture and farming. Proud of it. It's led us to be on the verge of becoming the 4th largest economy in the world as a state. And you have to follow the law. That's it. It's simple. If your business model requires you to violate antitrust law, to violate the rights of consumers, then you don't have a very good business model. You can profit and succeed and innovate and disrupt within the law. And we're here to make sure you do. So I am very pro-California business and very against businesses that break the law. And to me, there's no tension in that. Being a successful business within the bounds of the law, I think, is what every business person who dreamt about being a business owner and creating a business thought of. I don't think they were designing unlawful business models. They were trying to figure out how they can be the best in the market, in their sector, compete, provide the best product, the newest idea. So we love our law-abiding California businesses, and we will hold those in check when they break the law. And to me, it's pretty simple. Hi. With our injunctive relief. So as the structure that we have in a number of our settlements, we have compliance, as I mentioned in some of my opening statements, to ensure compliance with their injunctive relief, and then we always have a remedy to go back to court. This is a settlement enforced by a court, and lack of compliance can lead to court mandates and court action. So we don't expect non-compliance, and we have teeth and enforcement mechanisms if they fail to comply. Sorry.
The settlement in this case is $700 million. But you mentioned that there are 4 other cases, one for 93, one for 9, 2 others that are still pending. Do you think this is going to get the message? I mean, obviously it's a very powerful company, and these huge settlements haven't stopped them.
I mean, well, I think the facts and the law will dictate what we do against whom. And when the law and the facts demonstrate violations of the law, harm to consumers, violation of antitrust law, we will act. And Google, unfortunately, I mean, they have a whole variety of violations stemming over a long period of time. And they're being held to account by every state in the nation, the territories, and the federal government. You almost never see that much agreement by that variety of enforcers. But you see it here, and it's important that we team up and collaborate to hold them accountable. I don't know what the future holds. I don't see how you don't get the message when there's 5 different cases that have led to multi-million-dollar settlements, and some still pending that could lead to more. Our job is to continue to hold them to account as necessary. We're not picking on them or looking at them specifically. We're just looking at practices that hurt consumers and violate the law. And unfortunately, they've done it a number of times that have caught our attention. So whenever and the facts and the law dictate our involvement, we'll continue to pursue them. And I don't see how they don't get the message. Let's go over here. Thank you. So let me answer the first question first. So it's limited to Android users, and so that the $630 million will be provided to the 102 million Android users during the 7-year period of time. And when people purchase apps from the App Store or in-app purchases, they have been doing it through the Google Play billing system, and so they have records of who purchased what. They know who purchased what, when. And so that is a maintained database, which provides an opportunity to limit the burden on consumers and provide them their pro rata portion of the settlement. Thank you.
$2 doesn't get you much these days. I'm sure you want us to focus on the total number of the settlement, but can you put that in context of the underlying principles of this case and why it's important, even if it's only adds up to a little bit. I think people might dismiss it if they're looking forward to some sort of settlement and payoff and then realize it's only changed.
I mean, it's almost $1 billion. So to me, that's not small. But Google and other tech companies, they're generating revenues of billions and billions of dollars. And like almost all the time for our office, we're not focused on the damages, although we are focused on restitution for consumers, everyday people getting their money back that has been wrongfully, illegally taken from them. We're almost always more focused on the injunctive relief, the change in behavior, the fact that the law cannot be broken anymore going forward, that there will be more competition in the marketplace, the prices will go down, there'll be more options and more choices for consumers. That is the key of this case. The $700 million is not nothing, and it holds them to account, puts money back in hardworking Californians and Americans' pockets. But the punchline is the injunctive relief, the requirements that this company, who was harming consumers and gouging developers and small businesses and everyday people, that they can no longer do it. And they have to allow competition into the marketplace with app stores and direct billing.
It's also a testament to how big Google is in the marketplace, that so many people use it, right?
They're huge in many areas. This is just their Google Play Store. We're not talking even about search. And then, we have our ad tech. They are diversified and, active and successful. And at times, we have found in violation of the law. So we want to rein them in when they break the law and get their practices back in compliance with the law, which is what we've done here.
You talked about how, this is not a new accusation with Google. There's been a series of lawsuits over the years, but we keep finding cases where the company is accused of this type of behavior. What do you make of that? I mean, is it something in the company's culture where they just refuse to change these practices? Is there a calculation that it's worth their while to do these things and, deal with it when they get caught? What do you make of this pattern that continues despite all these cases?
Hard to get into the head and speculate about what certain people are thinking or doing. We're just looking at what they're doing. And the why may be something that we may never know, and we don't need to know. We're looking at what they're doing. And if it complies with the law, and if it hurts consumers, and if it does, as we found that it does multiple times, we act to change it, to protect consumers and stand up for everyday people. When you're large and you have a lot of leverage and power, I think there's a lot of temptation to use it to pad your profits and generate as much revenue as possible. Sometimes it's compliant with the law and sometimes it's not. And when it's not, it's important that we are there, monitoring and patrolling those boundaries for the people so that they don't cross the line and they're held in check when they violate the law. So that's what we look at. And if they know that if they violate the law, the California Attorney General and our California DOJ and perhaps AGs from every state in the nation and the territories will be there to stop them, maybe that will be an important factor as they make future decisions. Hi.
So there's another fairly well-known app store run by a California company. And,
to what are you referring? I want to. I'm kidding.
Not the Samsung Galaxy store. Google has made some fairly serious pro-competitive concessions in the settlement. Will you be looking at Apple, investigating Apple, and pushing them to make similar pro-competitive changes?
We don't comment on pending or potential investigations. We do think that the injunctive relief that we have here with the Google Play Store is a model for other app stores, and the ability for a consumer to purchase directly from the app without paying the commission, and for the developer to show the app developer to steer consumers to other purchasing options, that billing choice, all that is good for the ecosystem and doesn't just apply for the Google Play Store. It could apply for other, including California app stores. Any other questions? Do you want to add anything, Paula? Okay. Thank you for having us. Appreciate it. Thanks for being here.